So well, I guess we can get back to it. So yeah, Judge Moss, if you want to tell us just the differences between reversed, vacated, remanded, once we get those decisions from either the appeals court or the Supreme Court.
My understanding is that if a decision I issued, let's say after a hotly contested trial, then that's an appeal. It's appealed. If the decision is reversed, it means it's your order was completely wrong. So it was either like an error of law. And so if it's reversed, it's reversed. If a judgment is vacated, any order, let's say like an attorney's fees order or something, the Supreme Court can vacate that and just completely vacate it. The word remanded means if it's either reversed or vacated and remanded, that means it would go back to me to make either further findings or to actually rule with the guidelines contained in the appellate court decision and say, you have to follow these guidelines or follow these laws, and then properly issue the decision. That's kind of my understanding of that.
Marshall, do you have anything to add to that?
No, the easiest way of conceptualizing it is that when a case is vacated, it's been ripped out of the ground, root and stem, and anything that flowed from it is gone as well. A reversal simply says that they have found an error of law or fact, and for some reason want to do something about it. A case from about 20 years ago, a couple of cases that came out a couple of weeks apart will illustrate the point. In the Gardner case, the Supreme Court reversed and remanded, saying, okay, you got it wrong, Judge, and we want you to do X, Y, Z, go fix it on remand. In the Springer case, which was just a few weeks different than that, they said, well, the judge got it wrong, but we're just going to change the order, and here's the way the order is going to read now. Bang, 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 bang. So there was nothing further for the district court to do. The Supreme Court handled what they thought the final order would be. A remand means that there's got to be further action at the district court level to enforce whatever the appellate court said. And you would think that district court judges don't really have much of a choice, and most of our current family court judges are highly deferential. In the old days, it was a little bit different. There were a few judges that just said, I ain't going to change the order, and that required a second trip up. It's been known to happen. I've had a couple of those.
It just had one. Second trip up, reversed both times.
Oh,
The same thing.
well, so that's now on to a next question. I mean, so if we're reversed and then remanded, and then Judge Moss, you alluded a little bit to potentially instructions. So sometimes if you go up twice now, do you think the Supreme Court would then maybe give instructions at that point if there were before?
Well, they give instructions anyway, but what they often do if they're a little torqued, it's a bit of a subtle thing. They can say, okay, we're going to send it back down again, but this time we're going to have a different judge deal with it on remand. That's usually a neon highlighter that says, we don't even want you touching this again, Judge, because you're not following our instructions.
I can neither confirm nor deny if that's happened to me. But yeah, I think, let me just say for the attorneys listening in, practice tip, make sure when you draft the findings, unless the judge writes their own orders, I've written my own trial court decisions. Findings are super important. So if you're the attorney drafting the findings, a lot of times these appeals get remanded back for insufficient findings. And I see that a lot. So that's kind of what I learned over the 20 years. Make sure you have a very, very detailed trial decision.
One of them
are important, of course, because that's what the Supreme Court, the appeals court also look at, right? And if they don't have those, they can't even make a decision, right?
Yeah,
well,
I don't recommend copying the court minutes into a court order and make it the final decree.
I have
nothing against my court clerks, though. I mean, they're wonderful, but it's an attorney's responsibility to make sure there's proper findings and application to the law.
Sure. It does seem, I have seen in family court, I don't practice in family law in family court these days, but in the past when I have been a legal assistant and worked in family law cases, I have seen where it seems that the attorneys will say that the minutes are the thing and you have to do that. But it's good to hear from a judge that, no, you really do need to work together and come with actual findings that would make sense rather than just conforming to the minutes.
Minutes have no legal status at all. And if you want an explanation, I've got a legal note on our published, our newsletters page called The Use and Abuse of Court Minutes. You can read that. It'll tell you everything you need to know.
So, not the only one that's experienced, it sounds like. That's good.